Good morning. We're going to get started so we can stay on schedule. My name is Teneille Brown. I'm the director for the Center for Law and Biomedical Sciences, and I'm delighted to be the moderator for our panel today. I'm going to give brief introductions, then each speaker is going to speak for 15 minutes. I'm going to be a little bit strict on the timeline to make sure we have time for Q&A. And remember, if you want to ask questions, you can go to slido.com and enter hashtag 2025 Law Review, and then you can upvote those questions. So I will introduce each speaker right before they speak. We're going to have Louis Grossman go first. Louis Grossman is the Ann Loeb Bonfin Professor of Law at American University Washington College of Law, where he teaches food and drug law in addition to other classes. In January 2025, he taught food and drug law at Harvard Medical School. He is I'm sorry, my brain, just like, yeah, well, okay, but sorry about that. Little Freudian slip. Food and drug law at Harvard Law School. Louis is a scholar of both modern food and drug law and the history of the regulation of medical products and medical practice. See, there are like 5 medicals in there. I just threw the medical in. So join me in welcoming Louis Grossman, who's going to be setting the stage for our panel on FDA, politics, and public health.
Thanks, Teneille. It's a real pleasure to be here. I am a historian as well as a FDA lawyer, and I want to set us up on the issue of FDA operating within a political environment with 3 actual scenarios, or 3 clusters of scenarios. The first of which is one where FDA stood firm against political interference and pressure and ultimately succeeded. The second is a cluster of issues where FDA stood firm against political pressure, but ended up getting overturned or preempted by political players. And the third, very recent, very recent, is one where FDA simply folded to political pressure. So let me start with the first one, the episode in which FDA stood largely firm in the face of political pressure. I'm sure that because most people in this audience are under 50 years old, most of you have never heard of Laetrile. But some of I see some nodding out there, so people who share my decade of birth. It was a purported cancer therapy derived from apricot pits, and there was never any evidence for its efficacy except patient testimonials and uncontrolled administration of the drug. FDA, which received the authority to review drugs for effectiveness as well as safety in 1962, prohibited commerce in Laetrile starting in the early 1960s. But in the 1970s, Laetrile took the country by storm while knocking the medical establishment back on its heels. Proponents redubbed it vitamin B17 to take advantage of the surge of interest in health food and supplements and alternative medicine. And Americans of diverse political persuasions, by a wide margin, believed that people with cancer should have access to Laetrile. Now, the politics of Laetrile was fascinating and weird, kind of like Maha politics today. It reflected some permanent trends in American culture that continue to shape health policy today. Loss of trust in establishment institutions, including medicine and science, widespread embrace of conspiracy theories, including notions that the health industry was conspiring with government regulators to profit off American bodies, skepticism about modernism and technology, rights and choice rhetoric advanced against government public health regulation. And what we got was this very strange merger of right and left in support of Laetrile legalization. The drug peaked as a subject of popular interest in 1977, the year it received its highest level of political and public support. It dominated newspaper headlines. It appeared on the cover of Newsweek. It even became a storyline in Doonesbury. According to a mid-1977 poll, 94% of Americans had heard of Laetrile, and by a 2-to-1 margin supported legalizing it as opposed to continuing to prohibit it. Strikingly, in another hint of what would come in American health politics, that year alone, 13 states with diverse political leanings passed Laetrile legalization statutes. Within a couple of years, that number went up to 27. A medical freedom of choice bill that would have stripped FDA of its power to review drug efficacy received significant bipartisan support in Congress. And a district court enjoined FDA from fully enforcing its Laetrile ban. Despite this pressure, FDA never wavered, except in one respect. It approved an IND, which is an investigational new drug application, for National Cancer Institute studies of Laetrile, even though there had not been positive animal research that would normally be required to justify moving on to human studies. Most of the medical establishment, including FDA, ultimately concluded that the political pressures were so intense that the only way to cool what was known as Laetrilomania was to do studies and show that it didn't work. And that's what they did. The results of these studies in the early 1980s helped suppress interest in Laetrile. And FDA emerged from the Laetrile crisis with its reputation and self-regard largely intact. It retained the support of the Carter White House throughout the controversy. Congress ultimately didn't interfere. And importantly, the US Supreme Court ultimately had its back, upholding FDA's banning of the drug. How much time do I have left?
9 minutes and 4 seconds.
Oh, perfect. Okay. Now I want to give you a few episodes of the same era, or one a little later, when FDA stood firm, but Congress, in response to intense political pressure, even political outcry, combined with industry lobbying, directly intervened to reverse FDA regulatory actions. This happened in two very prominent instances in the 1970s. One concerned vitamin supplements, where Congress reversed FDA's decision to treat high-dosage vitamins A and D as prescription drugs. FDA's proposal of this led to an astonishing public outcry, leading to more letters to Congress and FDA than any issue ever. And Congress responded by passing the vitamin mineral amendments of 1976, which reversed FDA's rulemaking. In 1977, FDA, following the clear requirements of the food additive component of the Food and Drug Act, banned saccharin, which was at that time the only artificial sweetener left on the market, therefore meaning there would be no more diet soda in America. Again, it led to an enormous public outcry, and Congress passed a law directly reversing FDA's ban on saccharin. A similar thing happened in the early 1990s with respect to dietary supplements, where Congress responded to FDA plans to vigorously regulate dietary supplements with an act called DSHEA, the Dietary Supplement Health and Education Act, which limited the regulation on dietary supplements. Now I want to talk about a very different phenomenon, a situation where FDA itself responded to political pressure. And that was the AIDS activism of the late 1980s. That's Shannon. Where's Shannon? You in there somewhere? Shannon has already spoken about. This was a very different dynamic. FDA led the way in loosening regulations in response to public pressure. And I want to push back a little bit on Shannon's, the negative light she cast over that, because that particular movement did not have the support of the pharmaceutical industry. It was very much AIDS activist driven. The pharmaceutical industry itself was in many ways resisting the requests of the AIDS demonstrators. The picture that Shannon showed before was a major demonstration at FDA where AIDS activists took over the FDA headquarters, or at least the outside of them. What happened in this situation was patient activists educated themselves on pharmaceutical development and pharmaceutical science, and ultimately got inside the agency and worked closely with regulators to get drugs available before approval and approved more quickly. The specific measures were now under the rubric of treatment INDs, and that was making drugs available prior to approval for very serious conditions. Fast track, which is various ways in which the FDA can facilitate drug approval to make it happen faster, although not necessarily under lower standards of evidence. Sometimes that happens. And then accelerated approval, which Shannon mentioned, which while an arguably misused, not even arguably, obviously misused process, in the sense that many people don't do the necessary follow-up studies. I wouldn't throw the baby out with the bathwater, because I think it also led to some very important releases of drugs that were needed, including in the AIDS context itself. Finally, to finish up, how many minutes?
Now you are at, hold on a second, it's not showing minutes. You have about 5 minutes.
5 minutes. I want to talk about an event last week, which was the press conference that Trump held with RFK Jr. Concerning autism. My thoughts about this are just forming. The implications of it remain to be seen to some extent, but it was the most crassly political event, I would argue, in FDA history. The fact that Marty McCary was standing there behind them is astonishing. In some ways, by the way, I want to say that everyone's talking about the acetaminophen controversy, but there was another very important move that they made, and it had to do with a drug called leucovorin. Leucovorin is a derivative of vitamin B9, echoes of Laetrile, which they tried to categorize as a B vitamin. And Trump announced that FDA was going to approve leucovorin for cerebral folate deficiency, which they associated with Alzheimer's symptoms. And what I want to emphasize here is they're not talking about making the drug available to I may have just said Alzheimer's, I meant autism. They're not just making the drug available to autism patients, because it already is available to autism patients. It's an approved drug, and physicians are allowed to prescribe an approved drug off-label. The only thing really at stake is insurance reimbursement and a general promotion of the use of the drug. But what I find particularly striking is that the evidence base that FDA would use to change the labeling to include this indication is, and I say this tentatively because I haven't really looked at it carefully, but extraordinarily weak. I don't think that there's certainly no phase 2 trials. The FDA itself described it this way. FDA has conducted a systematic analysis of literature including, listen to what this includes, FDA's own words, published case reports with patient-level information as well as mechanistic data, and has determined that the information supports a finding that leucovorin calcium can help individuals suffering from CFD. And then Marty McCary says in the press release, we are using gold standard science. No, they're not. They're not using gold standard science. Gold standard science is adequate and well-controlled clinical trials. But notice what he then says. We're using gold standard science and common sense to deliver for the American people. This is you can argue that it's common sense or not common sense, but it is a common sense. I mean, it is the standard they're using is their vision of common sense, not gold standard science. So some concluding questions. Is the leucovorin situation more like FDA sensibly accommodating its approach in the AIDS context, or more like some kind of dystopian alternative history of Laetrile in which the FDA, instead of standing firm, surrendered its scientific integrity to political pressures? And there are differences from both these precedents as you consider this. First of all, autism is obviously a very different condition from cancer and AIDS. It's not fatal. Leucovorin is already approved for other uses, so this isn't letting the drug onto the market. Rather, it only has to do with the labeling of the drug. Up to now, in contrast to Laetrile and AIDS drugs, there's not much popular pressure or even patient advocacy pressure to provide access to this drug, as I understand it. But with Trump endorsing it, it may now become the new, ivermectin or hydroxychloroquine of this disease. FDA is almost being forced to act by pressure from the White House and HHS. And this didn't happen in either of the previous episodes. And then finally, when the FDA stood firm with Laetrile, the Supreme Court had its back. And with the changes in administrative law and the composition of the Supreme Court, I'm not so sure that would happen in this instance if it went all the way up to this nation's highest court. So I hope that sets the ground well, and I'm looking forward to hearing my co-panelists' presentations.
Thank you so much for that history, Louis. That was great. History repeats itself, although maybe worse second time around. So our next speaker is Sarah Karlin-Smith. Sarah Karlin-Smith is a health policy journalist who specializes in the policy and politics that affect the pharmaceutical industry. She covers the U.S. Food and Drug Administration, Centers for Medicare and Medicaid Services, and Congress, and other parts of federal and state government. Prior to returning to the Pink Sheet in March of 2020, she covered health policy at Politico for years. She is a regular panelist on the KFF Health News What the Health podcast. Please join me in welcoming Sarah Karlin-Smith.
Hi, everybody. Thank you for having me. So I'm sort of going to pick up actually perfectly a little bit in the middle of where Louis left off, kind of post-AIDS. We're going to skip a little bit of time and then get back to like leucovorin and autism. And I sort of started my thought process for this talk in thinking about there are going to be some presenters here that are going to talk a little bit more about like what is the appropriate balance for politics and involvement in FDA and science and how FDA should be structured. So just trying to get you guys up to speed on kind of where FDA has been then and what the sort of current law allows for. Prior to Trump actually taking office and before we even knew that RFK was going to be considered for HHS secretary, but we knew he was going to be like a big whisperer in Trump's ear, I started looking into, okay, so what authority could he or somebody who was influencing the HHS secretary or the politicals use to go after vaccines and the vaccine space? And I think what was interesting and what was emphasized to me is that a lot of what could or couldn't stop him was really norms and not law. And that a lot of the authority that people often think of as being, in the hands of FDA actually is delegated more informally down from duties Congress gave directly to the HHS secretary. Now, and then this is kind of where we're going to step back a little bit in history. For the most part, the norms have been that the HHS secretary and HHS in general has not weighed in on particular drug approvals and drug decisions, to the point that even at the Office of Commissioner level at FDA, which is really the part of FDA where there are traditionally a small number of political appointees, would not normally directly weigh in on drug approval decisions. They might be briefed on it and have some insight as to what's coming, but the tradition is that, the buck sort of stops at the center director level. Which is traditionally, again, probably until this administration, been seen as being led by career scientists. But we have Plan B. So in 2006 was kind of one of the more infamous times in the post-2000 era, I guess, where politics and FDA sort of clashed very publicly. And the FDA declined to approve an over-the-counter switch for Plan B. So people could access emergency contraceptive without a prescription. And at the time, that was signed off by the head of CDER, the Center for Drug Evaluation and Research. So it seemed as if it was coming from, again, that scientific level at FDA. There ended up being litigation around this decision and product, and through various discovery and testimony, it's probably the wrong legal term there, as part of that, it came out that Galson basically felt pressured from politicals as part of his ability to keep his job, to make the decision. And there were sort of some other interesting details, too, in terms of even how FDA's independent advisory committee was structured to review the drug, reports that, politicals had more interference than normal in terms of who was on that panel and so forth. And then you fast forward to 2011, and Plan B does get approved in this intermediate times for OTC access, but for people over 18. And then there's pressure to make it available to people younger than 18. And FDA was going to sign off on it. And what happens there is Kathleen Sebelius, who is Obama's secretary of HHS at that time, comes in, and she puts a halt to it. And she basically says there's not enough information, particularly for the youngest people who would be eligible for it, to safely use it in the over-the-counter context. And I think these two examples are interesting because you have, my editor wrote a piece at the time talking a little bit about how were there sort of advantages to the public perception, for the reputation of FDA and its scientists, for this decision, if perhaps seen as sort of non-scientific and politically driven, to be very clearly coming from the political level of the government and not from FDA. And there was clear documentation and publicly available that there was an FDA HHS dispute, and the politicals kind of exercised their authority to overturn it. And really, I think in my history of reporting on this, that was the big example people always talked about until COVID. When during the Trump administration, there was clearly a lot of undertones of political pressure during the emergency period to get products to patients faster. Two of the very probably well-known examples were around convalescent plasma and hydroxychloroquine. And both of these products didn't have to meet the same normal high FDA approval standard for traditional approval. They were operating in this emergency health period. You can get an EUA. That really wasn't a high bar. But there was very obvious political pressure, press conferences, maybe slightly toned down from the one, if anybody watched it on Monday, with autism and Luke of Warren. But you had the president, you had other people in these political positions sort of hyping up these drugs, sort of pressuring FDA to approve the drugs. And ultimately, both of them kind of fell on their face and were found to, really not work for the indications they were approved of. And even during the COVID period, I think one thing that I wanted to emphasize that is sometimes lost is that I think those Trump examples get a lot of attention and press and highlights of where they intervene. But I think there was some also in the Biden administration, some concern about how some of the decisions went down and whether there was pressure from the administration to approve things faster, to talk about drugs in the way you wouldn't expect politicals to do. There were some high-profile cases where Ashish Jha, who was the White House COVID coordinator, was basically making claims about soon-to-come COVID boosters scientifically that you sort of knew from the data FDA was requiring and the testing companies were doing was not going to be like realistically possible to make such like extreme claims about how good these boosters were going to be. And so I think around that era, there was a lot of tension between what FDA was doing and what the Biden White House wanted to do in terms of selling boosters to the public and their political agenda. I remember times when the FDA commissioner at the time, Califf, was tweeting, again, comments about Paxlovid, the antiviral for COVID, and as well as the booster shots. And again, sort of pushing the line on what FDA normally would say without evidence, and also even kind of making claims that they would normally go after the companies they regulate for, which struck me. I think the thing that strikes me kind of now fast forwarding to our current political environment is that in the past, there was a lot of distinction when you had FDA and kind of politics kind of intersecting, of there being kind of boundaries of there is FDA wanting to do scientific thing A, and you have the politicals and they kind of interfered and clashed. I think now there's a lot more blurring of the environment in that a lot of positions at FDA that we currently think of as being vested in career scientific leaders are now being held by people that are skirting those lines. So you have the heads of both the drug center and the biologic center really very clearly appointed by the FDA commissioner and working much more closely with the politicals to shape how FDA is doing things. And they're not only violating the norms around how things get approved, they're telegraphing it. So the first thing that really happened in this administration was the politicals intervened and stopped the full approval of the Novavax vaccine for COVID, which had pretty much been signed off, delivered, FDA was ready to go on this. And politicals pulled a halt on it and ended up changing the indication. And once that was revealed and it was public, later on, Marty McCary very publicly said, yes, like Tracy Beth Hogue, she's my assistant to the commissioner who was involved in this, and she's going to be involved in other approval decisions. And so that admission is not just like notable, it's notable that they feel comfortable saying that and being involved in this. The other thing I wanted to contrast with this and kind of jump back in time a little bit is that, and again, going back to, I think this is not just a Trump thing of political officials mentioning it. There were a number of controversial approvals over the last few years that I would couch as kind of in the scientific disagreement debate and not as much political interference, at least in the how you would characterize somebody's position. So there are a number of like infamous moments where Janet Woodcock, who was the longtime center director for drugs, and again would be seen as a career scientist, overruled her staff in approving certain drugs that have been deemed very controversial. Same with Peter Marks, which like ironically is part of why they fired him. But I think, again, that's like a different bucket in thinking about how interference works at FDA, in which, Califf at the time was the commissioner when the dispute over Janet Woodcock and Sarepta broke out for Exondys. Might be the wrong drug. But and, he basically declined to interfere and felt like the buck should sort of stop at the scientific level unless something really inappropriate came up. But I think another kind of high-level point to think about when you think about the FDA and drug approvals is that as much as we would like a lot of these decisions to be black and white, and I think this is often how Janet Woodcock defends herself, they're not mathematical equations, and the most controversial decisions are usually the ones where there is value judgment. There is some amount of, whether you want to call it political opinion or political values, involved. And so even at the lower scientific level, when you don't maybe, again, formally integrate politicals into this, you get, this tension that leads to politics and science interacting. But the last point I was just going to highlight is kind of some of the areas I've ticked off over this past administration, which again, I think has been unique in how the political environment has interfered with the FDA. There's been multiple now COVID vaccine approvals where the FDA has overruled career staff. There's been a couple of gene therapies. There's certainly, people are closely watching the abortion pill, mifepristone, and then you have Tylenol and leucovorin. Two things I think that are unique about that situation. One kind of answers a question somebody asked from the first panel. The FDA official rhetoric around, or official press statements and how they seem to be updating the Tylenol label is very different than if you watch the Trump press conference, which says don't take Tylenol, Tylenol is horrible. They actually have what seems like a semi-reasonably balanced statement about, we don't have causal evidence that Tylenol is linked to autism. And I think that is the contrast, again, between what is being publicly said by leaders in the media and what is coming out more formally through FDA. And I'm not sure if that's because they are trying to they know sort of to some extent what the difference between what they legally can do or what is there in the data and what they want to convey publicly. The other thing I think with leucovorin, which brings me to a broader point, which is GSK has indicated they are going to submit this supplemental application to get leucovorin indicated for what, we're not exactly sure, but something connected that they want to connect to the treatment of autism. And one question I've had since a lot of the Trump administration decisions and interference has started is where's the drug industry? Why aren't they suing? Yes, there is the legal authority of, these politicals to be involved in these decisions, but there is, and some of the lawyers can probably do a better job explaining this to me, there are some avenues, under the Administrative Procedures Act and other things where you could probably make legal cases to have gone after them here. FDA has clear guidance around what it expects for COVID vaccines that Novavax followed. So why have there been, no challenges in some cases to the industry, to the political interference? So I'm kind of interested in what those legal challenges could eventually be and why they don't happen.
Perfect timing. Look at that. 22 seconds left. Great, thank you. Thank you so much, Sarah. So next, and keep asking questions. Remember, hashtag 2025 Law Review. Next, we have Patti Zettler. Patti is the John W. Bricker Professor of Law at The Ohio State University, Moritz College of Law, and a faculty member at Ohio State's Drug Enforcement and Policy Center, the Tobacco Center of Regulatory Science at its Comprehensive Cancer Care Center. She works on all things FDA. From 23 to 2025, she served as Deputy General Counsel to the U.S. Department of Health and Human Services, covering the FDA portfolio, and before her academic career, she served as an Associate Chief Counsel in FDA's Office of the Chief Counsel. She received her undergraduate and law degrees from Stanford University, both with distinction. Please join me in welcoming Patti Zettler.
Okay. Well, thank you all. And I'm going to resist the urge to just respond to everything that was already said instead of doing the presentation I planned. But I do want to start out by thanking Daniel and the faculty and staff and the law review students here at Utah for their work to put this conference together. Fireproofing FDA, as we just heard, is more relevant by the day, and it's an honor to be included among this group of experts. And it's also a privilege to have the opportunity to talk with all of you about these issues that are so vital to the health and well-being of the American people. So I'm going to talk about a collaborative project with Rachel Sachs, who you'll get to hear from later today on a different topic. This is a project about FDA structure and somewhat responsive to the ideas that Louis and Sarah were just talking about. More specifically, we're thinking about how can FDA structure help or hinder public health regulators' ability to prioritize sound science in public health and account for legitimate shifts in priorities and policies. And one idea that's been floated by many folks at a number of points in time is to make FDA independent, either completely or partly from HHS, the White House, the Department of Justice, and other kinds of influence. We're using this project to explore the opposite idea. What is the strongest case? What are the best reasons for FDA's current structure? And as a side note, this is a ChatGPT generated image of the White House, FDA buildings and the HHS building. I don't think, for those of you who know the HHS Humphrey building, that it adequately captured just what a brutalist eyesore it is in DC. But I didn't have the patience to iterate to get a better image. Okay, so before I get started, I do want to be clear that this presentation represents my own views and not necessarily those of my employer, my past employers, or any funders. They're also not necessarily Rachel's views yet. We started thinking about this project while we were both serving at HHS, but we're still early in our thinking. And the good news for us is that, as Grant reminded us last night, papers aren't due until January 5th. So we've got some time to work out our ideas. But for today, I'll note that Rachel did not have a chance to evaluate what I'm saying in this presentation. So any errors and bad ideas are mine alone. All right, so with my time, I want to talk about three things. First, why should we be thinking about FDA's structure and independence right now? Second, what are the reasons that have motivated calls for greater FDA independence, which I think Louis and Sarah's remarks sort of highlight for you? And third, what is the strongest case, or what is a strong case against FDA independence? So first, why this topic now, given everything that's happened recently? Given everything that's happened in the last week, on Tylenol and leucovorin, this might seem a deeply weird time to consider why we might want to keep FDA connected to HHS and the White House and various forms of political influence, at least for those of us who are coming at this from a public health perspective. Sarah touched on sort of the unusual involvement of political appointees in the Novavax COVID vaccine approval. Both Louis and Sarah touched on Tylenol and leucovorin, and the role that political appointees and the Secretary of HHS, rather than career scientists at FDA or other HHS agencies, had. And Sarah, of course, has done great reporting on these issues, as have the other journalists joining us today. So you should follow their work. But I actually think that makes this the exact right time to be thinking about these structural questions and to deeply consider what the case is for keeping FDA structured as it currently is, as a non-independent agency within HHS. And this whole conference is about this, right? How should we be thinking about FDA going forward? We are obviously in a time of profound change at FDA, but also across the federal government. And however we come out of this moment, there may be an opportunity for significant reform. There are also upcoming opportunities for sort of more traditional avenues of reform. As George mentioned in the first panel, the user fee reauthorization legislation cycle is coming up, so there may be those avenues to think about what kinds of tweaks or changes to FDA statute could get included in those legislative changes. And I think because of those two things, right, we're maybe facing down some opportunities for significant reform, and we're looking at some of those traditional avenues for reform. We should expect lots of reform ideas to be floated. These ideas are already being floated. For example, Lowell Schiller, who served as Principal Associate Commissioner for Policy at FDA during the first Trump administration, and a couple of colleagues just a few weeks ago published a blueprint for FDA reform in the medical product space. And I'm sure we're going to hear lots of other ideas for reform today, right? And so in preparation, both for the opportunities for reform and in preparation for assessing the many proposals for reform that we're likely to see, we should start thinking about these questions now. And I do want to be clear that I think I think Rachel and I both are agnostic right now as to whether the right answer is to keep FDA structurally as it is or make it independent or something in between. So this talk itself is not a proposal for reform, but we are trying to think through the various arguments in favor and against FDA's current structure. All right, so what are the arguments for FDA independence, right? And these arguments for FDA independence have been around a long time, essentially as long as there have been changes to FDA's structure and organization. Some of those changes have been specific to FDA, as when in the 1960s, commissioners stopped being selected from among the career officials at the agency and started being selected from outside the agency. Others of those changes to how FDA operates are true for all administrative agencies, as when President Reagan issued a couple of executive orders establishing a centralized review system for regulations by the Office of Management and Budget, or OMB, that has led to the role that OMB plays today. And the most high-profile argument in favor of FDA independence in recent years came in 2019, when 7 former FDA commissioners from both Republican and Democratic administrations called for FDA to become an independent agency. They provide a number of reasons for independence, including a lot of the themes we've already heard about: promoting scientific integrity, reducing political influence, providing certainty for industry, promoting innovation, and improving efficiency, right? Just taking away layers of review. And they use as their motivating example FDA's efforts to implement food safety rules after the Food Safety and Modernization Act of 2011. And they talk about how long it took to get out those rules, over 5 years, even though there was an express mandate from Congress to move faster. And they contrast this with the product approval space, where FDA's ability to act more, FDA has been able to act more quickly. And as Sarah talked about, the norm has been no involvement from HHS, from political appointees, or from the White House. And these concerns about FDA independence or lack thereof, as Sarah noted, took on new life during the height of the COVID-19 pandemic, when there were concerns about political interference in FDA scientific assessments or in the ways that FDA might have otherwise talked about products that were available under emergency use authorization. And some of these concerns have been sort of articulated in other spaces, as well as folks here in the room with us today and other speakers have written about. Joseph, who we'll hear about in just a second, has written about FDA's lack of independent litigation authority. Daniel has written about the role of OMB in slowing down or stopping tobacco product regulation, as has my colleague Micah Berman at Ohio State. So there's lots of arguments out there in favor of independence. So with all that, how in the world could we think about not independence, right? So what are the arguments that we might not want to change the structure in ways that are radical? It's hard to imagine arguing against any of the underlying goals motivating the arguments for independence, right? Scientific integrity, public health, innovation, efficiency, these are all good things, transparency. But the question is whether independence as a structural matter or greater independence would serve those goals. With that in mind, I think the arguments against independence might fall into at least 2 buckets. First, FDA's current structure can serve public health and certain goals of administrative law and policy, such as democratic accountability. And second, there might be public health policy reasons that FDA's current structure serves because of the substantive interconnections between FDA's work and other public health regulators. So one argument against independence within that first bucket is of sort of administrative law and policy bucket, is the reality that FDA's decisions are not and cannot be purely scientific, as Holly Fernandez-Lynch and others have written about. They involved normative and therefore, or value judgments, as Sarah mentioned, and therefore political, or at least sort of like small p political considerations. And we might very well decide to defer to scientific expertise for certain kinds of decisions, like product approvals, and Congress has supported that deference in certain ways in which it has written FDA statute. But FDA does so much more than product approvals, including rules, guidance documents, public meetings, and so on. And so as long as the agency is following the law and is transparent and honest about the trade-offs it is making, there does seem to be room for legitimate shifts in policies and priorities from administration to administration or over time. And one might argue that is appropriate from a democratic accountability perspective. Admittedly, for those of us coming at this from a public health perspective, these shifts in priorities might trouble us in terms of substantive public health outcomes. I think Shannon's presentation touched on this, and some of Louis and Sarah's comments touched on this. What if an administration puts greater emphasis on post-market data and less emphasis on pre-market data? We might think that's a bad idea. But if there's an honest sort of airing of what trade-offs are being made and what policy choices are being made, that might be okay from sort of an administrative law and policy perspective. And shifts in priorities might also present opportunities to move FDA in ways that we think promote public health more optimally. And public trust in FDA is important. And we also don't know the counterfactual of what public trust in FDA would look like if FDA were more independent and potentially less politically accountable. We also don't know if actors within FDA would make the choices that we substantively agree with. As Sarah noted in her comments, a lot of the decisions that have been very controversial do involve questions of value judgments and scientific disagreement. And it's not the case that we're ever going to get an FDA that for each of us personally always makes the decision that we think is the one that should have been made. So there are these administrative law and policy trade-offs to making FDA more independent potentially. And the second bucket of reasons I mentioned are FDA's substantive connections with the work of other agencies. In other words, are there public health policy reasons why we might want FDA to maintain its connections as they are now? So yes, FDA's authorities are powerful, and a well-functioning FDA is of course vital for public health, but FDA's authorities and role in public health are in many ways deeply intertwined with the work of other HHS agencies and with HHS itself. And we might think about pandemic preparedness as just one example, right? Responding to an emerging infectious disease outbreak can require tight coordination, ideally, among many different agencies. NIH might do basic science to understand the problem. CDC might track human health and deploy resources to state and local governments. FDA, too, depending on the situation, might track spread of the disease and work to find ways to facilitate the development and authorization of medical countermeasures. The Administration for Strategic Preparedness and Response, or ASPR, might acquire and deploy countermeasures from the strategic stockpile, and BARDA, the Biomedical Advanced Research and Development Authority, might work with companies on prioritization and development. And the authorities to act in these kinds of situations are also often overlapping. FDA and CDC, for example, share authority under the Public Health Service Act to address communicable disease. Coordinating well certainly isn't impossible with FDA outside HHS, and FDA does have a good working relationship, or has historically, with certain agencies outside HHS. But it's probably hard to argue that kind of work is not facilitated by having FDA within HHS. There's a clear chain of command to decide questions of law and policy, including when there are disagreements. There's alignment of overall missions, and there's an ease of sharing information and working together in situations that can be incredibly time sensitive and high pressure. And so, there might be public health policy reasons that FDA's work is better and the work of other public health regulators is better when they are connected. And ultimately, that's better for the health of the American people. In other words, many of us, of course, are FDA scholars or FDA lawyers, and we think about FDA, but FDA is part of a larger ecosystem of public health communities and public health regulation. All right, so these are some preliminary ideas about why we might want to keep FDA in its current structure. And again, I want to emphasize that I framed this as an argument in favor of FDA's current structure, but we're not necessarily, in the end, arguing for that per se. I think what we are arguing for is a clear-eyed assessment of the benefits and risks, to put it in sort of FDA terms, right? The benefits and risks of FDA's interconnections within HHS and with other agencies. All right, so thank you all for your time, and I'm looking forward to our Q&A session after Joseph's talk.
This is a spectacular group, but you're saying such timely and wonderful things and in time, so that's great. Our next and final speaker is Joseph Daval. Joseph Daval is a research specialist with Portal, the program on regulation, therapeutics, and law at Harvard Medical School and Brigham and Women's Hospital, where he studies prescription drug law and policy. Joseph received his JD from Yale Law School, where he served as an editor of the Yale Law Journal. Maybe has some tips for our law review editors for their journal, and has served as an attorney in the FDA Office of Chief Counsel. Please join me in welcoming Joseph.
Thanks. And I'll start by echoing the thanks to Daniel, the law school faculty and staff, and the Law Review for putting this together. I'm really glad to be here. And I'll note as a preliminary matter that much of what I know about FDA law and policy and the history of the FDA and the pharmaceutical industry, I know from reading Louis and Sarah and Patti. And so I'm honored to be on this panel with them. Since the 1960s, the FDA has relied heavily on the advice of experts outside the agency, including physicians, public health experts, and epidemiologists. And since 1972, those consultations have taken the form of advisory committee meetings, most notably when deciding whether to approve new drugs. Advisory committees are a way for the FDA to obtain reliable, actionable advice and also to demonstrate to the public that it's making its decisions in a scientifically rigorous way. The FDA usually follows its advisors' advice about 88% of the time for drug regulation questions between 2010 and 2021. The FDA's use of advisory committees has also decreased within that same time frame. In the early 2010s, over half of newly approved drugs had been reviewed by an advisory committee, but by 2021, that had dropped to fewer than 10% of new drugs. Similarly, the number of advisory committee meetings held on drug products dropped from over 40 a year to below 20 a year. The kind of strange result is that FDA has continued to closely follow its advisors' advice while it has asked them fewer and fewer questions. But this year has seen by far the biggest changes to the use of advisory committees at the FDA. Only 10 meetings from all product areas have been convened or scheduled so far, of which 4 meetings reviewed a total of 7 new drug applications, which is the fewest I'm aware of. This is consistent with reports from within the agency that leadership has simply stopped scheduling new meetings. Meanwhile, the FDA has begun holding what it calls expert panels on subjects of particular interest to the Make America Healthy Again, or MAHA movement, with panelists seemingly handpicked to share views that are known in advance to align with popular positions within the MAHA movement. So far, it has held 4 such meetings on antidepressants and pregnancy, hormone replacement therapy and menopause, talc additives, and infant formula, with another scheduled for October on food allergies. To the untrained eye, these expert panels look a lot like advisory committees, but they are not. Advisory committees are standing committees that are consulted periodically, whereas members of the expert panels are invited to speak for a single meeting. Advisory committee members are screened for conflicts of interest, whereas expert panelists seemingly are not. Instead, some panelists self-announce conflicts before speaking. Advisory committees are typically presented with a set of discussion questions or voting questions from the FDA and a presentation from the FDA giving the advisors a shared set of facts to interpret. They usually conclude with a vote on a regulatory question, about 79% of the time for human drug advisory committees from 2010 to 2021. By contrast, expert panels involve no FDA presentation or questions presented to the panelists formally. Instead, the panelists each talk for about 5 minutes and present any information they choose. Advisory committees can last anywhere from 5 hours to 18 hours over 2 days, whereas expert panels are about 2 hours long. But perhaps the biggest difference is that advisory committees are designed to comply with the Federal Advisory Committee Act, whereas the expert panels are not. The Federal Advisory Committee Act, or FACA, was passed in 1972 during the good government era of statutes that also includes the Freedom of Information Act. FACA says that any time an agency utilizes an external group for purposes of recommendations or advice, it has to comply with certain requirements, including opening the meeting to the public, publishing all relevant documents, including a transcript, and announcing the meeting in advance in the Federal Register. FACA grew in part out of a concern about perceived capture of agency policy by special interest groups. And so it includes language about ensuring that committee membership is, quote, fairly balanced, unquote, and that its advice, quote, will not be inappropriately influenced by the appointing authority or by any special interest, but will instead be the result of the advisory committee's independent judgment, unquote. So why don't these requirements seem to apply to the expert panels? For starters, I'm not sure that they don't. It sure looks a lot like the FDA is utilizing an external group for advice or recommendations. And if they were encompassed by FACA, they would be unlawful because besides being recorded and posted on YouTube, they do not comply with FACA's requirements. We could imagine lawsuits challenging the membership as not fairly balanced or as being inappropriately influenced by the appointing authority. Courts are willing to review committee membership for FACA compliance in extreme cases. The DC District Court, for example, has previously found that an advisory committee at the Department of Justice violated the fair balance requirement. But the reason FACA may not apply, or at least FDA's best defense here that it doesn't, is that they're not giving advice as a group. This distinction was articulated by the DC Circuit in 1993, writing, "A group is a FACA advisory committee when it is asked to render advice or recommendations as a group and not as a collection of individuals." It wrote that advisory committees, quote, "possess a kind of political legitimacy as representative bodies," unquote, but that they bestow this legitimacy, quote, "only insofar as their members act as a group. The whole, in other words, must be greater than the sum of the parts," unquote. The FDA seems to be aware of this exception to FACA's requirements. On its webpage for the expert panels, it says that, quote, "individual experts may offer their recommendations for regulatory action," unquote, which reads to me as drafted with the aim of putting the panels outside of FACA's reach. FDA has often used this exception in the past in the context of the many workshops and listening sessions that it holds, although those typically aim to solicit stakeholder input from patient groups or industry rather than advice from qualified experts. The FDA website descriptions of the expert panels are careful to avoid any implication that the panel is being asked to deliberate collectively or reach consensus, which would imply rendering advice as a group. But a court might not see much of a difference there. At the end of the day, you've got a bunch of experts sitting around a table telling the FDA what they think it should do. The panels seem engineered to give the appearance of a true advisory committee with the legitimacy that can lend to FDA's decisions without actually having to face an independent advisory committee it can't predict. It seems plausible a federal court could see it this way too. But even if a court were to hold that these panels violated FACA, I'm not under any illusions that the FDA would suddenly move toward a more scientifically rigorous, accountable way of operating. The truth is that if a public health agency's leadership is bent on performing pseudoscience theater, it has many stages on which to do so, and there is little anyone can do to stop it, at least in the near term. FACA was designed to prevent interest group capture from outside the agency. That's not what's happening here. One worthwhile reform would be for Congress to more clearly specify when FDA must consult its advisors before making regulatory decisions like drug approvals. The Food, Drug, and Cosmetic Act already requires that FDA's advisory committees on new drug approvals, quote, "meet regularly and at appropriate intervals," unquote, implying that FDA can't simply stop convening them altogether, as it appears to be doing now, although I don't know who would have standing to bring that challenge. We might also imagine an expansion of FACA to cover groups like the expert panels, but this seems like a bad idea because we want the FDA to be able to hold stakeholder listening sessions and similar events. Making those comply with FACA would render them unworkable. FACA's requirements are quite burdensome on agencies. It takes a lot of time and resources for the FDA to obtain high-quality, independent expert advice when it wants it. I'm not in favor of repealing FACA. I think it's a really good thing that the public can see those interactions, and on balance, probably worth the costs. But I want to be clear that I'm not necessarily defending FACA or the advisory committee system at the FDA as they existed prior to this administration. There's a lot of room for improvement there. But what is most troubling about all of this is what it says about the FDA's relationship to politics. It's bad enough that the FDA is turning away from consulting independent experts to inform the exercise of its regulatory authority, but it's also doing something else. It's moving towards panels that are handpicked to seemingly convey messages to a motivated political constituency, saying, "We hear you, we see you, and now that we're in charge, we haven't forgotten about you." That seems genuinely new. The FDA has never been apolitical. Of course, all agencies exist in a broader political context. And the FDA makes inescapable value judgments every day, at every level, affecting the products it regulates and the people who depend on them. But politics in the narrow sense of electoral politics, of seeking to hold the support of a voting bloc, has now arrived at the FDA, and it is hard to imagine a path forward without major structural reform to insulate the FDA from it. What we are seeing at the FDA today is the disastrous result of many things, but a big one is our failure to distance the agency from the blast radius of our national presidential elections. A belief in self-government does not require this particular arrangement. We can imagine others. Moving forward, it will be up primarily to Congress to reassert its role as the architect and overseer of federal agencies, and up to all of us to assert a coherent alternative of what the FDA's relationship to electoral politics should be. Thanks.
That was terrific. And I love the way you all built on each other. That was really great. So we have a little more than 15 minutes for questions. We have many that are already in the queue, so I'll go ahead and ask the one that has the most votes. And then whoever feels comfortable answering, you can just jump in. 2 days ago, RFK Jr. said he intended for the FDA to review the safety profile of mifepristone, a pill approved 25 years ago and commonly and safely used to induce abortions. What exactly does this mean? What can FDA do within its authority to review mifepristone?
I can start, and I imagine Louis, at least, might have things to say also. Okay, I'm going to move that closer because it doesn't bend down. I think one thing we heard on the presentations, this morning, is that FDA does have post-market authorities, right? So just because a product was approved 25 years ago doesn't mean FDA doesn't have any authority to continue to review it. And FDA for mifepristone and a number of other drugs has required something known as a risk evaluation and mitigation strategy, which imposes certain conditions on use of the drug, and FDA is authorized to require that when it's necessary to ensure that benefits outweigh the risks. If I put on my teaching hat for the law students in the room, I would encourage you all to think about the Administrative Procedure Act that Sarah alluded to. And if you are representing the companies that market mifepristone, what kinds of challenges could you bring to an agency decision that might involve considerations of things that are not in the statute? And the things in the statute, as I mentioned, are focused on safety and effectiveness or benefits outweighing risks, which generally involve sort of scientific questions. So there might be arguments, for example, that a decision that is based on something outside those statutory criteria is arbitrary and capricious under the Administrative Procedure Act. And here, there would be parties that have standing, the companies themselves, and states have also challenged certain aspects of FDA's regulation of mifepristone. But I will, I think, stop there and see what others want to say.
So I want to give the disclosure that I authored a brief on behalf of many of the other FDA scholars in this room defending FDA's approval and regulation of mifepristone.
And I will disclose that Louis represented me in that brief.
But there's so much to say about this, but just one thing I want to reflect on is people have different attitudes towards abortion care and whether it should be available. And these are genuine moral disputes and things that, are properly subject to the political process, subject to constitutional limits. What I'm keeping my eye on with this is the extent to which that science is warped on behalf of a desired outcome. And there is a lot of science on the safety of mifepristone. And one thing that would really trouble me is if this science were cherry-picked, manipulated, and so forth in order to justify what is not truly a public health decision, but rather a moral decision, without even questioning that moral decision. So the judge in the Northern District of Texas who ruled first on this, and maybe Patti can help me or you can help me, cited like not just non-peer-reviewed, but like blog science or something like that.
Retracted study.
Yeah, retracted studies. Do you remember exactly what it was?
I do not.
Okay. But to choose science that is not true science and then to ignore results you don't like and to manipulate the scientific record is just a very troubling thing I think, for any FDA scholar.
I will add to what Louis said that, as Louis noted, there's been litigation over FDA's regulation of mifepristone. There's a variety of litigation directly challenging various FDA decisions. There's also litigation about whether certain state restrictions on either abortion care or on the drug itself are preempted. And a message I tend to give, and I gave last week at an industry event, is that we might think that these lawsuits are motivated by the kinds of moral concerns Louis alluded to, and that might be right. But the legal questions are FDA law and administrative law questions. So whatever the outcome of those lawsuits are, it's going to have a big impact on the pharmaceutical industry, on innovation, and on the way things are done for all drugs. So the legal questions are the kinds of things Louis is talking about. They're about how do you interpret the provisions of FDA statute and what kinds of evidence are legitimately considered by the agency given the authority that Congress has given FDA, right? What do the words of the statute say, and is the agency following the statute?
Yeah, moderator's privilege here a little bit. It sounds like what's also happening is they're taking anecdotes of outcomes that may be negative but are completely predictable with mifepristone, like cramping and significant bleeding, and people go to the emergency room and they're told that's expected. Maybe it's more of like an informed consent issue to the extent there are side effects, but they're predictable. But they're using those little anecdotes instead of looking at population data and clinical trials. Did anyone else want to answer that? Yeah, go for it, sir.
I was just going to say, if I was sort of a betting person, one thing that Commissioner McCary has sort of teed up in terms of, I think what they are looking at if they do anything is probably to somehow modify the risk evaluation and mitigation strategy to somehow limit access. And he seems very interested in going after in-person dispensing, which in terms of access would be problematic because of when they say in-person dispensing, he seems to want to bring back the requirement that a woman actually go to her doctor and take the pill in front of whoever is prescribing it. So that would not only make like telemedicine not useful for many women who live in states where you cannot access the pill otherwise, but it would take away a lot of other types of prescribing, and he very often repeats these sort of narratives that people are being given pills they do not want to take, in sort of private situations by partners or whoever who wants them to have an abortion and they don't. And I think that is like an interesting conversation because I think you could probably make that about any. There's so many drugs you could do that to, so it's interesting that they're honing in on this. And I want to...
Like psychiatric drugs, right?
I also want to emphasize what Patti was saying just now. A lot of the people that read, like my publication, are brand drug companies. Mifepristone is a generic drug. And so in a lot of ways, like they don't have a lot of financial stake in what happens to mifepristone. It doesn't interest them, but there's so much interest in this drug and what happens not just at FDA, but in the court battles going on because of the concerns of the precedent of when judges and the courts weigh in on science versus, when they're weighing in on more sort of process or legal issues around what FDA can and cannot do. And I think that's like kind of the key hook that makes everybody worried right now. And it'd be very interesting because it has been the concern is like FDA made scientifically valid decisions. Will the court do that thing? And then I don't know what happens if you get something that's seen as less scientific from FDA, how the courts handle that.
Right. Did you want to answer? Okay, great. We'll move on to the next question. I think this is maybe for Joseph. It seems like it hits on some of the points you made. How do you think or Sarah as well, how do you think the public got it so twisted and both hate medical authority because they perceive it to be captured by big pharma, while also supporting supplement manufacturers who are touting ineffective or unsafe supplements and directly making money from this. So the idea that there are conflicts on the MAHA side with the influencers pushing supplements, that seems to be okay, even though that's a conflict of interest. But then conflicts of interest via medical professionals, those are unacceptable. Any thoughts on how that story, if we should be worried about conflicts, right? But why are we more worried about it in one context and not the other?
I'm not going to speculate too much on kind of what I think the origins of the MAHA movement are. Honestly, I'd be curious to hear Lewis's thoughts on that. In some way, it seems to resemble prior historical movements like the Laetrile kind of political constituency, but in other ways is different. I'm not going to get too far into that. In terms of conflicts of interest, I don't know what to say much about it beyond that it seems like an inconsistent position, and that it is being kind of leveraged for certain political outcomes by agency leadership.
Great, thanks. Did you have any thoughts on kind of a comms issue? Anyone else want to jump in?
This is my baby.
Go for it, go for it.
I mean, I think about these issues a lot, and I could go on, but let me just point out a couple of things. Attitudes in American culture that resurged in the 1970s, but actually go back even further than that to even the 19th century. When Americans look at pharmaceuticals versus dietary supplements, first of all, many Americans see things that are scientifically developed and supported by the scientific establishment versus things that are less so. And if you have an anti-establishment attitude and view with suspicion what the pharmaceutical industry and its federal regulators do, that is going to lead you to favor dietary supplements. There's also a cult of the natural in America, the notion that anything that is like not the product of high technology, but rather something that God has bestowed upon the earth that people are taking. This doesn't describe all supplements, but it describes many supplements, and that has always fed into the difference. Another huge difference is the role of patents. Laetrile is not patentable, and most dietary supplements are not patentable, and so therefore the profits to be made from them are enormous. Whereas dietary supplements use ingredients for uses for the most part that aren't patentable, and so although they profit, they don't seem to make as much money as the pharmaceutical industry. And I have a lot of other thoughts on this, and I think it's a really great question, but it really emblematizes a lot of aspects of Americans' attitude towards health and medicine.
Anyone else? Move on. Okay, we have two more that are tied, so I'm going to go with the shorter one maybe first. This is a comparative law question. Do politics play the same role in other countries on their FDA equivalents? If you know. If you don't know, we can move on. Have any other countries figured out how to avoid or minimize the problems caused by political interference?
I don't know the comparative law answer. Maybe someone else does. But I guess I do want to push back a little bit on the idea that politics, if this is part of what's underlying the question, that small p politics, maybe not the electoral politics Joseph was talking about, have no role to play. I think different countries might make different value judgments about what they want their approval standard to be, how they want to regulate different products. Do they want to err more on the side of caution or more on the side of openness? I think the sort of American approach, right, tends to be less on the side of precaution and more on the side of allowing companies to market products, maybe particularly in the supplement and cosmetic space that Lewis was talking about. So, I don't know if different countries have addressed political interference per se, or if they have just struck different value judgments about where to draw the line with respect to sort of risk and uncertainty.
I will say, with respect to Europe in particular, I had a long discussion with a reporter from the French paper Le Monde last week, and she reported to me from her cohort in France, because she's a cohort of France, not all France, they think we're going insane. And they're wondering what's happening. But it's worth noting that one way that Europe helps insulate decision-making in this area from political pressure is by making it decided by European bureaucrats rather than by nation-specific authorities. And you could argue that that's better or that's worse, but it certainly has certain downsides to the respect that there is politics invariably associated with food and drug law. How do people's authentic views of those, small p political decisions filter up or not to a group of bureaucrats sitting in Brussels?
This is really more of a hypothesis, but I know, like, in European countries, the sort of the gatekeeping of who gets access to drugs is more impacted on a national level by their cost effectiveness bodies that kind of decide how they do price setting, which is not something we really do in the U.S. in terms of our insurance system. So I think that there may be more I don't know if there is, but I wonder if there's more focus on kind of the politics element at that level. There was something else in my head. I can't think of it. If I think of it,
yeah, jump back to it. Great. All right, we'll move on to the next question. You actually saved us, Joseph, so now we have even more time for questions. I think of Operation Warp Speed as an incredible example of government efficiency and safe acceleration of drug approval. Is this an accurate characterization? If so, why did it work while other examples of acceleration and political pressure seem dangerous or corrupt? Any thoughts on that one?
I can start. So I think one thing to keep in mind about Operation Warp Speed is what, I don't want to say unique, but what an unusual situation we were in the height of the COVID-19 pandemic, because it was possible to generate data far more rapidly about things like the COVID-19 vaccines than it is in a non-sort of pandemic setting. The other thing to keep in mind is that particularly for not the vaccines, for which FDA held a quite high standard for safety and effectiveness, but for the therapies, as Sarah mentioned, those products came on the market through an emergency use authorization, which is something FDA can do. I'll spare you all the sort of legislative details, but something FDA can do in public health emergencies where Congress allows but does not require FDA to authorize the marketing of products that are promising but not yet proven. So the standard is lower as a matter of law, for FDA to authorize products under that pathway.
Something I'll add real quick is that the underlying facts of Operation Warp Speed, and when we're kind of comparing that to the controversial approvals like the accelerated approvals, are entirely different. The vaccines are just so overwhelmingly effective, were so overwhelmingly effective, that we don't run into the same kind of difficult questions that we do in the case of the Alzheimer's drugs, aducanumab, lecanemab, as the Duchenne muscular dystrophy drugs like eteplirsen, where the efficacy is really kind of unclear and you kind of have to squint to see it. I don't want to imagine the world that we would be in if COVID efficacy of the vaccines looked like that. But I think part of why Operation Warp Speed can kind of stand as such a success is because the underlying efficacy of the vaccines was just so high.
I was going to say, and the Operation Warp Speed was also sort of set up, they insulated themselves in some ways from politics that could have come after if the vaccines hadn't been so successful, because the FDA had very clear written guidance. And I think they actually were going to be they were aiming for like 50% effectiveness, which now seems incredibly low. But you sort of had a sense of where they were going to try and draw the line. So I think that helped them. And it's interesting that the areas where there's been the most controversy going forth with COVID vaccines has been the area where they sometimes teased that they were going to lay out like very more specific standards or thought processes or like around booster development and how that should be done. And they never did that. So it was like harder to gauge kind of whether the administration was following kind of FDA's own policies and scientific standards.
Okay, so we're going to have Louis Grossman, who one of the questioners said, why is he the coolest person in FDA law and policy? No offense to anyone else on the panelists. I'm going to guess they asked the question. We're going to let him have the last word, and then we're going to go to lunch down the hall.
If I remember correctly, the vaccines were also approved under EUA. And so the EUA kind of got a bad name because it was used with respect to hydroxychloroquine and ivermectin. But to me, the use of the EUA in the context of the vaccines showed kind of like a very measured response, taking into account the fact that vaccine uptake itself depends on people trusting the science behind the vaccine.
Yeah, sorry to be clear. I didn't mean to suggest they weren't initially on the market under an EUA, but that FDA, as Sarah said, set a very high standard for what.
Yeah, so some people argue that they should have given EUA approval based on a challenge trial, gotten it out there earlier and saved thousands or hundreds of thousands of lives. But they actually required controlled trials, if I remember correctly. This is my memory. Before approving those vaccines. And there were public health reasons to do that, not just with respect to the efficacy and safety of the vaccines themselves, but the trust that the population would have on them. And my final thought is with respect to this, these were mRNA vaccines, and the current administration using kind of this sort of like anti-technology philosophy has basically announced it is now against all mRNA vaccines. And so the next time one of these pandemics arises, we're going to have to rely on other technologies, not that one.
Kind of like the cult of the natural, you were saying. Well, please join me in thanking our speakers, Joseph, Patti, Sarah, and Louis.